Hello and welcome to the LawCast. We are now on season two. We're back and we've got some great new guests for you this season. This season's probably going to run to about eight episodes, talking about a whole range of different topics and news articles and things like that. And we got a whole big old range of guests coming with us for this season. The first of which I'm really pleased to have on is Craig Matthews, who's the CEO of the new Leap Estates, which has very recently come about as a whole new separate piece of software that runs as part of Leap and with Leap. So, welcome, Craig. Thanks for joining me.
Yeah, great to be here, buddy.
Yeah, really cool. I'm very much looking forward to learning a lot about Leap Estates and what it does. And we're going to sort of see in this episode how how software is developing with various changes in the law. And the main topic that we're going to be talking about today is the Powers of Attorney Act 2023, and what's happening with that, and from a software perspective and a legal perspective on that front. So really great to have you, Craig. Thank you for being here. But what we're going to do, we're going to have a brief chat about some news, some things going on in the news. And the one of the things that has cropped up recently is the Legal Services Board and the Law Society very recently have done a survey called the Legal Needs Survey 2023, and that's recently come out. And it's just to have a look at who needs solicitors, who needs the law, and what we're sort of seeing in the areas of law utilised. And something that actually surprised me, the figure here, Craig, is that according to this new research, 2 in 3 people across England and Wales have faced legal problems and had a legal issue in the last 4 years. And now, to me, that seems like quite a
High
high
numbers,
number.
right? Yeah,
Yeah, it's
absolutely.
like
Yeah.
66% of people. What do you
Well,
make of that?
interesting. So I think that the housing market's gone through a boom, right? In post COVID, so we saw a lot of people buying and selling properties, which would put a lot of the I guess the UK population into that kind of sphere of people who have taken some sort of legal advice or employed a lawyer to assist them with the matter. Um, from my very sort of insular area, looking at that kind of estate planning piece, interestingly, the number of disputed estates is increasing rapidly. I think this could largely be down to the value of estates now, right? So estates are worth a lot more, and if an estate is queried and ends up going through a dispute, then it can take a heck of a long time for that to go through the necessary channels for that money to be distributed. Most recently, the stats are saying that kind of like about 75% of people expect to come into some sort of estate dispute matter. So look into that 2/3 of people who've deployed legal services. Yeah, it kind of tallies with that there is that requirement for it. I think it says a lot to everyone about the importance of getting your wills, your LPAs in place at an early point to sort of stop that being a major issue. But most certainly, the trend we're seeing within sort of my specialist subject, if you like, is an increased requirement for legal advice throughout people's lifetimes.
Yeah, it's really interesting because one of the things that they've brought up in this survey is that they reckon that 3 in 5 of those experiencing a legal issue is a contentious one, which I wonder if that's including these kind of disputes that you're talking about with regard to estates and stuff like that.
Yeah, I very much expect so. And the I think what's really sad around the whole contentious probate area, of course, is that invariably it tends to be family members, and very often that regardless of the end result, the rift between the family is irreconcilable. So that is just generally sad. There are, of course, some potentially spurious claims being made because people see that there's lots of money and they know that it can be tied up. So I had a really interesting conversation with one of our firms who had worked with a law firm. Sorry, worked with a person for many years, and they'd had like 10 or 11 revisions of the will, and fortunately that person passed away. And they were dealing with a probate, and a letter came through from a local law firm saying that my my client was left out of the will, and they looked into it, and the client was a next door neighbor, and the next door neighbor had supposedly been promised a large expensive car, and because they had such detailed record, they went back and this person A had never had a large expensive car in the whole time, and B, no provision for that person had ever been made in the previous 11 revisions of the will. So was able to go back and say, look, this appears to be a spurious claim. There is A, no car, and B, there is no information. But you can see that if that law firm hadn't had that level of depth in the way in which they'd recorded that information, then where does that claim go? There's a person who's passed away who supposedly had offered someone a sum of money or a car, whatever it might be. No provision in the will. First thing everyone sort of says in that instance is they then start questioning testamentary capacity. Well, did they forget? Did they leave me out? It wasn't on purpose. They've written it, but they forgot to add it. And of course, this is really difficult. And that there are things that can be put in place. Of course, it's not going to stop every dispute, but having those wills written with a letter of wishes that explains it, having it clearly written in plain English so you can understand exactly how you want your estate to be bequeathed, and where you are, leaving people out who might expect to be in there, then kind of making it known, right? Making it known that was your decision in your letter of wishes, and there are things that can be done. It won't stop every claim, but yeah, certainly there are a number of claims coming into this space, and I think there's like a 38% increase in the last 2 years of one. You hope that a lot of it goes via mediation and never kind of makes the courtroom, but there are, even for that, they are invariably going to want to be speaking to a law firm about it, and need to get their advice prior to probably entering the mediation route.
Are we finding that because at the moment, like everything's difficult, isn't it? Like everything's really, really expensive, right? It doesn't matter who you are. That the cost of living has affected everyone. Are we finding? Is that possibly? Is this possibly related to that? Like a result of that, where people are struggling, and yes, unfortunately, a member of their family passed away, whatever, and then it's almost like they're doing everything they can to get the most out of whatever's been left, and is there sort of contention derived from that? Perhaps, maybe.
I think possibly. I mean, the individual circumstance to each case, will obviously be different. But yeah, I think that at a time when kind of everything is difficult, like you said, there is just general difficulty and hardship being felt by so many people that perhaps there's potentially almost an opportunistic element of some claims. Not every claim. A lot of claims will be completely valid and legitimate, but I do think that maybe there is that it is an area of law that we perhaps haven't seen that kind of attitude towards, but maybe that is shifting a bit, and say that whether or not that's also in line with the fact that estates are perhaps worth so much more than they used to be, and that of course largely tied to the property price and the increase in property price. So property that maybe 30 years ago would be 80,000 could now be worth £750,000. It's massively differences, and it obviously has outweighed the increase in general salaries and cost of living. Property is one of those assets that outperforms on a regular basis, even post crash and stuff. It tends to outperform. So yeah, I think that's an interesting thing at the moment. The flip side of that is you do occasionally see some people who tend to be asset rich but cash poor. So who are people who perhaps need to consider their estates at an earlier point to work out whether or not there is something they can do about kind of managing that estate better to give them a better position of living than they are by just having this really great house but can't afford to heat it, kind of thing. So it's a very interesting time when you've got those kind of competing factors that the assumption is if you've got a big house you can afford to heat it. Well, actually, because some of the house prices have gone up and that's not been reflected in earnings, it can kind of flip over as well, which is it's a very, very interesting sort of dynamic we find ourselves in at the moment.
I think one thing that I see from all of this is very much a case of make your will and keep it updated, and stay in contact with your local solicitor, essentially, or your local law firm, and make sure that as best you can, make sure that it's right and updated regularly, to try and avoid any of the kind of he said she said 15 years ago
Yeah,
kind of conversation, right?
you're 100% right, and actually I think it's a real play for the local law firm as well, because obviously we live relatively close to one another, and we kind of know the areas in town we live in. So, if you've got a house, central Great Malvern down by the train station, that's going to be £1 million plus, right? So we know that because we know the postcode, we know the streets.
Mm-hmm.
Local lawyers know that, right? And we also know that other property in Malvern maybe won't be quite so expensive. If you're looking towards using a law firm from the other side of the country and you gave them those two addresses, they might not necessarily understand the full nature of your estate, and therefore kind of probably where your kids go to school, where the people might work and all that kind of stuff. So that local knowledge in this area, I think actually is really important, because the more you understand your area and your clientele, the better you can advise them on that, and the more that you will be able to continue to advise them through their lifetime. It's a tough thing as well, right? It's facing up to that, to the fact that we might not be here one day is tough, and the younger you are, the tougher it is. COVID kind of showed us that there's no guarantees we're going to live long lives, even if we are super healthy. So that kind of had a bit of an impact at one point, but that seemed to have gone away. And the average age of person making the will today is around that 58 mark, which I think is really kind of quite old. I think there's probably more that law firms can do potentially to bring it to the attention of people they're dealing with, especially if they are dealing with the number of people we've just discussed at the start, so 66% of us. If you're buying or selling a property, making a massive change to your asset portfolio, you need a will, and not to be reminded you need a will when it comes to the all completed, you're done and dusted, and you moved in, and then you get a letter saying we recommend you make a will, because of course no one reads that. You've just moved into your house, you've forgotten about it, you've got so many other things they held. I think that conversation needs to take place when you're talking about the ownership of the property, jointly owned or tenants in common, and then also actually consider whether or not, if somebody didn't have access to their bank account, could the mortgage be paid? Do we need to look at LPAs to make sure there's financial control in place when you're doing that kind of stuff? If you go into any family matter, then of course it's probably going to have an impact on the way in which you might want your estate to be distributed, getting divorced, things with children. That again needs to route into to the private client team and the wills and probate team to have conversations around how that kind of impacts things. Anything to do with injury or personal injury, then that's going to affect you from a financial point of view, in that you're going to receive a lump sum of money, or it hasn't had an impact on your life and how you live your day. Again, is it time to consider that estate? And then, of course, within the corporate department, if you're dealing with businesses, then you're dealing with business owners, and those business owners are probably going to fall in that high net worth or the ultra high net worth area. Well, most certainly they need estate planning, because they're going to have big estates. So kind of, it feels to me that kind of every individual department in the standard law firm is kind of a feeder into that wills and lifetime planning area. And the more you engage with that person, the more they'll understand your estate, your requirements, your desires, and the better they can work with you to protect your assets and make sure that what you want to happen happens. Even giving advice on the lines of that 7 years prior to death, you can give gifts that aren't taxable. Well, if you've got some kids and you want to get them on the housing market, then actually maybe making that decision earlier rather than later means you get to see them enjoy their property, and that when you die, 40% of it won't be taxed on IHT as well. So again, engaging in that regular conversation means you're having that, rather than saying, well, I'm going to do a will when I'm 50 and I'm not going to look at it again. There are lots of things that in that period of time that you may want to reconsider with your assets as to how best to utilize it, and that's it, right? So it's all about, for us all, it's all about the enjoyment of our lives, right? And the most we can make from it. And regrettably, there is a fixed time we're going to be on this earth, so let's enjoy it as best we can.
Absolutely. Well, there we go. So engage with your local law firm, get a will, especially if you bought property, and keep it up to date. There's some really good advice there. So moving on to my next little bit of news, and it's to do with sort of interest rates on client account now. As part of a probate after we're talking after wills now.
Yeah.
Don't want to get too morbid for this for our opening episode, but we have a situation where when estates are dealt with and the length of time that it takes for estates to be sort of divvied up, property sold, and all that kind of stuff, and legacies and things to be paid out, law firms can be holding a significant amount of client money. Now, historically, I say historically, probably since the first crash, so 2008, when during this long period of time when interest rates went through the floor, during that period the SRA put out a rule where as a law firm, you had to create your own interest policy and provide a fair sum of interest to your client. Now, when the interest rates were next to nothing, a fair sum of interest to your clients was nothing, because you'd have
no one's getting anything, right?
No one's getting anything. So it was reasonable for you to say, we don't pay client interest because we're not getting any client interest. So, however, things have changed, as we know, very recent history, and interest rates have gone back up. Although they have stabilized now, they have stabilized at a point where we are starting to accrue significant amounts of interest. And the SRA are starting to have a look at this. And one thing the SRA has said is that the total net interest income rose over 1,000% to 27.5 million last year, in comparison to 2.6 million in 2022. So that's a lot of money, right? So, but the thing is that, as with a lot of the time with law firms who are under the cosh and they're just getting on with it, they're doing the job, they're working really hard, interest policies are not top of their agenda. But the SRA is starting to see that they haven't changed it. No. So they're not accounting to their client anymore for a fair and reasonable sum of interest on those client monies. And that's something that what are we now? We're 25th of recording of this, we're 25th of April. So we're sort of like year end time. This year, 24-25, is when, in my opinion, firms need to start assessing those policies and making sure, because they do start accounting for a fair and reasonable sum of interest. Because I have a feeling that during some audits ending, say, March 24, I have a feeling there are going to be some auditors out there that pick up on the fact that the interest policy is still showing zero.
Yeah, I think it's an interesting point. I think question is, does it go back into kind of the fundamentals of being a law firm and a lawyer? Are you behaving ethically towards your client? Crazy thing. If all of a sudden you are holding £1 million and you've got interest in the region of £40,000 accrued on that, then is that yours or is it the client? Well, I think ethically, we would probably say it's the client's. So there's going to be those. There's going to be the need to update those policies, but I think there's probably that also need for everyone just to be fair about this, right? And kind of understand that that's a thing. And you're probably right. Unless people are thinking about it, it's in the news a lot about how it's impacting mortgage rates and savings, but not necessarily does that kind of translate directly into how it's impacting things you do on a day-to-day basis, which is absolutely understandable, right? We have our houses and lives outside of our professions. But yeah, I think you're right, and I think all of a sudden, if there are large sums of money going into an interest pot, then auditors are going to start kind of questioning that. And of course, you'll correct me if I'm wrong, but it was kind of why the SRA put the 14-day requirement a long time ago, was to prevent law firms holding money on their own account and having to put it into a designated deposit account at a certain point, so that high levels of interest couldn't be accrued without it then being given back to the solicitors. And I wonder, not such a thing then when there was that when there was no interest, but when you've interest at 4 or 5, back in the old days 8%, then that's big sums of money.
Yeah, it's a lot. Because when I started doing this in 2000, and the first client that I ever worked on had like 20, 30 designated deposit accounts for their long-running estate files, long-running probate files. And it worked because it was completely separate from the main pot. And it worked really well. And basically, it would accrue, and then when they paid out all the legacies, they would say, right, all interest and everything gets paid out, close it, and then
Yeah.
that's then divvied out. And it worked really, really well. But of course, since then, there's been no, since sort of like 2008, 9,
Yeah.
no
But no
reason
need
to
to.
use them. So it's just stayed in the main pot, and then what tiny dismal little bit of interest that they did get would go into Office account.
Yeah.
But it's
Yeah.
different. It's
Yeah.
different
Quite
again
right.
now, and maybe
Yeah.
maybe we are going to start seeing designated accounts reappear.
Yeah. I think there'll be people saying this feels vaguely familiar, and it was it was 15 years ago you did it regularly. Yeah, I think we may very well see that kind of, and the ability to do that and keep it separate and then do it, and then when you come to doing your estate residue, it would just be a kind of a lump sum in the estate accounts, and it would be split accordingly based upon the way in which the will has been written. So yeah, that's kind of where I'm potentially for seeing that going. All to be seen, but you would think it might just go back to as it was when interest rates were high before.
Yeah, and I think I mean software can also help with the interest calculation, can't it, and all that kind of thing. So we kind of like, I would be looking at this point, because obviously for the last few years, as we said, we haven't really needed to, but I'm looking now at software to basically say, well, okay, we're going to make it really easy for you to calculate what your interest is on this matter. We're kind of at the point now with software where we should be able to just kind of go, okay, click, and it say, oh, this is what your interest is. So it'd be really, really nice to start seeing that, and that sort of become much more of a part of a regular day-to-day thing for cashiers. Just click, bang, okay, that's the interest, and away we go. And
you're right. I mean, I remember a long time ago, kind of, the interest calculator side of the accounting software was key, and everyone was interested in how it worked and how it would allocate the interest out. But yeah, it kind of hasn't been an item discussed often during demonstrations for many years, because there's been no need to, right?
Exactly.
But yeah, I wonder whether or not we'll start seeing that increasingly onus on that when there are software demonstrations going on, just to discuss how it's dealing with that interest calculations and designated deposit accounts. All of a sudden now sort of make their way back into the accounts demonstrations going forward.
Yeah, makes you wonder if there's a selling point there.
Absolutely.
Which software provider is going to be the first one to go, hey, we do a really good interest calculator, guys? Right, so interest on your client account, please. I'm begging you, don't ignore your policy, go back to it, have a look at it. If it still says we don't pay client interest, you please have a rethink, talk to your COFA, and try and get that sorted out, and agree what a fair sum is likely to be. Please do it before your next audit. So yeah, that's my advice. That's my advice for the day. So moving on from that, we're going to sort of have a look at our kind of main topic. And at the end of last year, it was October 2023. There was a Powers of Attorney Act 2023 got royal assent. And what Craig and I are going to be chatting about now is just about what's changed, what to look out for, and sort of how software can help with this kind of thing. I think the main thing that I've noticed that's changed, is the biggest one, I suppose, is the digitization of the powers of attorney, and the fact that they're trying to streamline the whole process, rather than downloading the documents, filling it all out by hand, getting it sent backwards and forwards, and it taking a hell of a long time to get through.
Yeah, like it's a major change, huge change, especially for this area of law. So obviously the probate registry went online a couple of years back now. Wills remain requiring that wet signature, and there can only ever be one copy of the will. So for the LPA to kind of move into that digital space, I think is really, really interesting. I think it also kind of just highlights the significance going into the estate planning area of law in general, right? There is more focus on this now. People are seeing it as such an important part of their overall firm offering, and then as individuals, we're seeing the importance of these documents. Again, documents that we don't want to make or don't really want to think about making, but having them, and of course whenever you speak to anyone who's got them, it just gives you that peace of mind. Like life's easy when you know they're in place. So yeah, absolutely great. How we communicate that out across to all 69 million of us, I'm not exactly sure, but that's the message that hopefully this podcast is going to kind of help get out there a little bit more. But yeah, going down the route of making them digitally, I guess the big pushback for many years has been the security about it. About how do you know the person is not under duress, who's not being forced to do it? And I think that's probably being scrutinized more from a digital perspective than perhaps it would have done on the paper forms. But interestingly, of course, there is no guarantee that simply because you did it paper and you force someone to sign it, they weren't under duress anyway. So often the arguments around is it secure? It can be very easy to argue the same points about the paper methodology. So it's nice to see the government have kind of embraced that, and they are looking towards moving this into a digital area. Of course, they must keep it open for those who want to register themselves as a private individual, as well as those who want to use a professional to work with it. And of course, on that professional side, you've got those who would be a regulated professional, and then those who sit in the unregulated space of professionals. So the will writers, the estate planners that don't have the either SILEX or the SRA, the Law Society kind of badge to it. So it's a very interesting and quite a difficult solution, I'd imagine the OPG are coming up with at the moment to try and create a single method that's going to work for those people. And of course, it may also be that someone starts doing it themselves and then later down the line says, actually, this is a bit more involved than I thought it is. I'm going to get a solicitor. Well, they're going to have this unique number that then needs to be passed from person to person to make sure that process can remain in line.
Yeah, I think for me the important part of all of this is ensuring all the ID checks and ensuring that everyone is who they say they are. And that's a huge topic at the moment. Especially I know SRA and Law Society are looking at it. And I know it's a big buzz at the moment, dealing with things like source of funds and AML and all this kind of stuff, and just making sure that everyone is who they say they are and can prove it. And I think for me, I actually think that the whole digital thing should make that better and should make it easier, because you have to have access to all of those documents and proof that can then be stored centrally and verified digitally.
And I think that this is one of the interesting bits. Is very much the government should be in the best position to enable us to do that, right? So we may have tax accounts, right? Well, they know it's me logging on to pay tax. There's lots of things we do from a government point of view that we can do through digital means. Passports can be done now as well. So I think what we're going to see is we're going to see the government requiring that level of checking. It will be interesting to see whether or not they will accept any other independent checks as government approved checks, or the standard will be of a certain point that's what they're going to require. We're very fortunate to be part of the working party, both with our Leap Estates hat on and also the WillSuite team hat on as well. And one of the points they made, which was quite interesting, was that whereby a solicitor is applying for a power of attorney on behalf of an individual, they will accept that the solicitor will have done their own AML and KYC checks, and that would then be accepted. Whereas for perhaps an estate planner who doesn't have the same requirements under the SRA guidelines, they would still require the individual to prove they are who they say they are. And of course, that kind of puts those two professions at a slight advantage, disadvantage on that basis. But then, for lots of law firms who are doing this, they're all going to be doing all these things because they have to, and they've been doing them for a long time anyway. So being able to do that independently is key. I think the interesting bit for me, perhaps more so than the person we're doing the application for, is that witnessing process going digital as well. And I think that will be and sending out the documents in order to get it signed. I think that what we're probably going to see, and this is my own speculation, it's nothing guaranteed. The OPG is still working really hard on the solution. Will be some sort of portal-based process whereby it's done and verified and agreed, and then signed by the donor, perhaps, and then it will be fired off to the other people within the chain that need it to be done, and we will all be expected to log into a single portal, identify ourselves, provide that ID check, sign it, and then it would go back into that process. And I think that's going to be particularly interesting. I think there will remain the paper requirement, and they said a lot of people, especially those people who make the wills, and we said 58 years of age plus tends to be the standard at the moment. So a lot of people who are doing these LPAs are going to be, perhaps not wanting to use those digital methods. A lot of people are going to want to use them, but that's going to be quite key. And I think what we'll probably see is that software providers are going to have to be building in their processes to that government portal, and therefore if you're doing it as a standard Word document and thinking I might be able to get away with it being docu-signed, I would be surprised if that would be accepted. I think we're probably going to see that there's going to be a portal. I'm keeping my fingers crossed there's going to be a really good API that we can plug into, and we're going to then be getting that data, but I expect it will kind of almost be managed and processed by the government portal. I suppose a little bit like how we integrate with the land registry, how we integrate with the PI claims portal. The CRM is going to have the information, it's going to be imported into it, and then the journey will be conducted through that government-based portal. And the flip side of this, of course, Alex, is we've been able to digitally sign property transfers for quite a while now. So actually, there are areas of law where digitalization has not created high levels of risk. In fact, it has simplified the process. Mm-hmm. So, if we think of the importance and the value behind making fundamental changes to land registry register, then you can see why it's the right time to implement this, and that as long as we're doing it to the same level or a higher level, then it will be interesting to see how it's adopted. Definitely the lawyers I've spoken to are very much looking forward to it. They are wary of it. They want to make sure it's safe. They know it's their reputation, their clients they're looking for. They want to make sure it's done properly. But provided it comes out well, then I think it's going to be a really great thing for the profession and for us as a nation.
Yeah, I think the modernizing of it is when you're dealing with things like wills or any kind of major change, or in this case power of attorney. As you said right at the start when we were talking about it, it's not something that you really want to do. You don't jump out of bed in the morning and be like, "Oh, I want to make this. I want to make an LPA or whatever." So the easier that it can be for the client, essentially, the better. And do you know what I mean?
Well, yeah, maybe, but there are risks, right? And this is a fundamental thing I think with LPAs. Is it? And one of the concerns is it might be too easy to do.
Too easy, okay.
You might just go on there and just fill it in, click the boxes. I've got an LPA. But the issue is, unless you fully understand what you're entering into that LPA and making appropriate provisions over, if someone is going to provide you care, that you have made a provision for them to be able to receive a payment of some extent for the care they're providing, and all these things, then you can find yourself in a position where you've got an LPA in place, but because you've had to give up your job to care for somebody, and that you are therefore using an element of the donor's income to support your income because you're not working because of that unless there's a preference or provision made for that, then actually you could find that a deputy has to step in because you're kind of going outside of what you are allowed to do. Mm-hmm. And that can be fixed with having a conversation with the law firm and explaining to them what the provision is, and they'll say, okay, well, we need to do this, or we need to do this, or we need to do this. Whereas if you're just saying, right, I'm going to give somebody full rights on my behalf, well, then that might not protect them, but also it might not protect you unless you understand the provisions in with which they can make those decisions and understand the laws behind that. Then yeah, and that's definitely a concern, and I can see why it's a concern, because these are such important documents and these people are alive whilst these decisions are being made on their behalf. One would hope that the people you asked to be your attorneys are going to be ethical and they're going to treat you in your best interest. But again, there are horror stories out there where that's not always been the case. And the concept here is that if someone's got to go through the trouble of printing off a document, filling it in by hand, getting it signed and sent across, well, that might be more hassle than it would feel that if you just jumped online, logged in, pressed a couple of buttons, did it. I do think that process is going to be a load more involved, so it's not going to be that easy. But yeah, there is definitely a concern that by making it too easy to do, but by making the user interface, too simplistic and not really kind of explaining the full intricacies of what's going on, that there could be instances whereby bad LPAs are drafted, and therefore they don't have the provision. So yeah, it like with everything, that the more you know about it, I suppose, the more you realize you don't know enough about it. and definitely the more I understand this area of law, then you think that the idea of popping to WH Smith to do a DIY will would be just a really bad idea. It's about getting the legal advice from the people who are absolutely spot on this, and what they can do in half hours. And it's taken them 12, 13 years to qualify to get to the point that they can do it in half hour. Right? That's why they're so good at this. And the assumption that you can kind of do it yourself, whilst there might be a facility to do it yourself, whether or not you should do it yourself, I think that's an interesting one, and one that I think the profession as a whole is wary of, because invariably if there are bad LPAs in place, then there's going to be core protection matters that are going to come through from it, and there's going to be a lot of work for law firms to do, but not the work they really want to do. What they want to do is help them not make the mistakes in the first instance. It's the same with the estate dispute we discussed initially. It's about getting the right things in provision to prevent it going bad, rather than deal with the the fallout of it. And I think that is a big concern for the profession, and something that I think we all need to be aware of as well. That there are things you can do online, but whether or not you should do them online are different things. Some of us do our own tax returns, and that's great, and you can knock them all off. But if you've got a particularly complex estate, or you've got a number of properties and you're not sure about what you can and can't, claim back for, then that's when you call an accountant in, because you need that special assistance. You can do it, not always the best to do it, and I think that's going to be quite an interesting one that the profession will be maybe dealing with for when it first comes out, then potentially for some time thereafter. The flip side of that, of course, I suppose, Alex, is that not everyone knows what an LPA is anyway, right? So yeah, if you ask 10 people, I don't know how many would say, "Oh, I know exactly what a lasting power of attorney is. I know exactly what they do, and I know what they are." So I do think that the whole will and LPA area of law is one that isn't particularly well known across the public of the UK, and I do think there should be more of an understanding of the importance of these documents. But again, how you reach that many people, is always going to be difficult.
Yeah, I definitely think it's anything like this is you've got to go through basically your local law firm every time.
Yeah.
What I would say, just don't do it on your own. You wouldn't, do you know what I mean? You wouldn't, but you can't buy, you wouldn't go buy a house on your own or something like that, would you?
We go back to your very first stat, right? As why there is 66% of the population taking legal advice. It's because they know what they're doing, right?
Yes.
It's because it's the right thing to do. So the fact that there is that many, of course, it doesn't. Of course, you say a lot of it is contentious, but then conversely, 2/5 is not contentious. So it'll be things like buying a property, getting wills, getting LPAs, people taking the right decision to go and speak to law firms about it, and making sure that they're dealing with it properly, and it's they've got the provision of service. So that is I think that's a flipping the stat. There's a positive element of that stat as well, in that people are going to law firms for non-contentious things. Again, you can do your own divorce, you can do your own conveyance, you can do your own will, you can do your own LPA. Should you do any of those things? Well,
yeah, exactly.
That's the different bit, right? That's the different bit.
Yeah. So what would you say, because a lot of changes, obviously it's digitizing, and we were talking about, you mentioned earlier about the possibility of it's possible eventually there may be some sort of government portal which can sync to software and stuff like that. What sort of things would you say that other things that software and other developments that you might see of software could make to that sort of ties in with these changes of digitizing everything. We're going to sort
Yeah,
of see things, like for example within Leap Estates or something like that, where where it's going to sort of like gear itself towards the changes in the act, so to speak.
yeah. I think it's really interesting, and the way that Leap Estates kind of came about was I joined the team at Leap just over 2 years ago to really head up and focus on the private client area of law. So if you think back of last 20 plus years I've been in legal technology, each area of law has had a bit of a focus. There's been loads of time and effort spent on prop tech, and there's all sorts of solutions for buying and selling houses more effectively. Family law has had all the bundling coming together. Personal injury have had their own portal. You've got legal aid work all going through the LAA portals as well, and a lot of area of law have had a lot of focus from tech providers, legal software providers, hopefully assisting and perfecting that area of law to make it really simple. And I think it's fair to say that private client space kind of hasn't had that same love and attention just from the business, the legal software industry as a whole. So very often what happens is you find that the private client department are kind of forced to use whatever the conveyancing department wanted or whatever the family or litigation department wanted, and they kind of make their most with it, and they create a couple of precedents, and they kind of work as best they can. So it was a great opportunity within Leap to say, well, what can we do to make this way better? So one of the first things we did is we brought in an integration with WillSuite, who are a will and LPA drafting specialist business, and that now sits integrated with the application. We took another look at the way in which we deal with estate administration and really revolutionized that to make it a lot easier to be putting your assets on and managing your estate assets and liabilities through that. And then really as a part of that conversation, what we realized is that when you look at this space, it isn't just law firms who operate in this space. There are the will writers, there are accountants, there are IFAs, there are estate planners. And Leap Estates, the concept that was born to create this end-to-end private client solution where we get to spend all of our time and effort as a small division within Leap of just concentrate on this area of law. And having been the CEO at a legal software company before and having to worry about every area of law, it's lovely being the CEO and only worrying about one area of law, because I get to put all my time, effort, love, and focus into just private client and how we can really kind of revolutionize this and bring it up to spec and have the same kind of facility and end user experience that a conveyance would expect, as and kind of just almost even the playing field. You could easily walk into a law firm and find that the conveyancing team completely paperless and fully digital and loving life, and the poor private practitioners next door are kind of making do with some precedents and copy and pasting and putting in clauses, and you think, well, that's a doorway apart, and it's very, very different. So what we're doing within Leap Estates and the larger Leap group is looking towards making sure that every area of a law firm has the very greatest tools they need to perform the work as effectively as possible. And things like the LPA reforms, and I do believe there's going to be a digital onus on that API. The fact that digital wills is now going back to a further consultation, again, that says to me that that's probably going to follow something along the same lines as the LPA, and maybe they'll see how the LPA goes and whether or not there'll be a facility in the future for us to be able to digitally sign wills as well, and whether or not it runs through the same portal. Again, all this is speculation, but you can see that even the government are saying, actually, we need to start providing more digital services because there is this surge in requirement for it. And invariably, that is going to attract, that's why we've got this software focus where we are focused on making the Leap and the Leap Estates provision of this area of law as good as possible, really.
That's good. Yeah, it makes me wonder with all this digitization whether we are actually then going to see a surge of clients, because it becomes easier for the firm to deal with things, and therefore easier for the client to get on board and actually take the step of making a will and creating a power of attorney with a law firm.
Yeah, very, very, very possibly, and that can be a good thing, right? I mean, the more of us who have wills and are regularly reviewing our wills, the better. Reviewing them, at least every 3 to 5 years, more often if you're a high net worth individual, but again, more often again if something's happened, if you've inherited some money, or you've had a child, or you've moved house, or you've got assets abroad. Any of these things should be kind of individual triggers for us. And of course, the more that we operate with a law firm, the easier it will be for us to do business with them, and them to be able to provide us with that really great solution. It's it is hard for the general public, right? Going to a law firm is kind of not something we look forward to, but like going to the dentist, right? We know we have to do it now and again, but we don't necessarily want to. I think with this area of law, it's an area where you can kind of be welcomed with open arms and say, well, it's you're making the right decision. Let's just talk it through. Let's converse about it, and let's make this an ongoing collaborative thing, so we can make sure that every time I'm here, any queries or questions you've got, I'm going to be able to assist you with it, and we can make sure that for the here and now with your LPAs, and then for the future when you're not here, that you are looked after and managed appropriately. And I think it's a really great way of law firms kind of working more collectively with the client, and and if that person is buying and selling a property whilst they're working with their private client department, well, then you send them to your property department, or if that that private client solicitor or private client has an employment issue, you send them to your employment department. But you can almost be that kind of like that gel that really kind of brings that client into the protection of your business going forward. And I think that's a really, really positive way of kind of looking towards moving this solution, rather than it being a transactional. We do a will once and we'll forget about it until probate. Hopefully, it's this ongoing dialogue with the clients. And because we do change our lives more regularly, we perhaps back when the laws were written, we never used to get divorced, and we would have probably bequeath assets to kids only, and that would be it. Because we do live life differently, and there's no fault divorce, which is definitely seen an increase in the people who are considering remarrying and things of that nature. And intestacy laws make no provisions for stepchildren. Blended families are the norm. Then actually going back and talking to your law firm regularly is should be a sort of standard part of what we do as we grow, really.
No, I agree. I 100% agree with that. I feel that it's all about being looked after, like on an ongoing basis, and then having the confidence as a client, the confidence the client to go, I'm going to ring up so and so at the firm, and I've just got to talk to them about this. I just need to, and what's great, because now that we've got software like like Leap and others, the documentation and all of the resources are sort of at your fingertips as a lawyer, as a secretary. They're all at your fingertips, and you can just go and grab it. Oh, okay, what matter are we talking about? I guess this one, load it up, bang, there it is. There's all the stuff. Whereas historically, you might have a file that thick somewhere,
archive somewhere, absolutely,
and it becomes that much harder,
especially to find it. Absolutely,
and you guarantee they'll, the person will call on sort of a Friday morning at about 11 o'clock, so it's the way that tech has developed, I think has been really beneficial for the end user. But I'm wondering if we're starting to see a bit of it. It sounds like, for want of a better term, a bit of a U-turn, because we had a lot of everyone sort of went to go and see their small law firm, their local law firm, whatever. But then there was sort of a rise initially in tech capability, and we saw this surge of bigger firms doing bigger things, and it being almost like your law firm felt a little bit like a call center kind of thing. You know what I mean? And you didn't sort of get that one-to-one, really sort of like personal service. You didn't feel looked after. It was more like a means to an end. And you hope that you get to the end, and it would be as
very transactional,
Right, exactly. I'm wondering if with the advancement in this kind of technology and all that kind of stuff, we're starting to see it a bit U-turn, going back towards a smaller law firm and a local law firm, where, because they have now the ability because the tech is accessible to those smaller firms, they now have the ability to do everything that all of these huge firms were able to do, but also with it provide that really lovely one-to-one service where the client
local service
after.
Yeah, I think you're absolutely right. I think tech can be the platform lever, right? You can have your own branded app and client interface portal, and it doesn't cost hundreds of thousands of pounds, and you don't need your own development team to do that anymore. There are great provisions out there for those kind of services. You can have all your data available wherever you are, whether or not you're working from home or abroad or in the office or your second office. You have that, so you can level the playing field in terms of the technologically solution that these bigger guys are deploying. But then where you get to enhance that is that local level of service that is very hard to provide unless you are a local law firm and you know what's going on, right? So I just think it's a hugely exciting time for those law firms, and being able to kind of really look after and maintain their clients is invariably what most lawyers want to do, is to provide the very best service to their clients possible. We'll embrace technology, allow that to help you, so you can do the real key bits of what you're doing, which is where you are trained in your specialist sort of subjects.
Yeah, absolutely. It's lovely to see, and it's nice to see that the smaller law firms are really sort of engaging with it, and
Oh yeah,
things
hugely.
things like this, the powers of attorney change, where they are looking at digitizing and trying to make life easier generally for the firm. I think can only be a positive thing, providing it's done and all the due diligence is done. So, like you were saying, we don't want to make it too easy, and we've just got to be very, very careful and just bite-sized chunks, one step at a time. Make sure that all the I's are dotted and T's are crossed. And then with a view to making it generally easier for the firm to then provide that service to the client, which is really great. And I'm pleased that we do have forward-thinking software out there that's keeping an eye on these changes and is willing to adapt and move forward and be sort of at the forefront, almost sitting there waiting for the change to come in, so that straight away it's like bang, okay, well we now integrate with this and we can do that. So really, really great. I'm really pleased about that. So we're sort of rolling towards the end of our little podcast for episode 1, and Craig, I'm very grateful for you for joining me. Perhaps you'd be able to sort of give us a little bit more detail about Leap Estates, or any developments that are coming, or things that you're going on. We can find you. That'd be really great.
Absolutely. Yeah, thanks, Alex. Yeah, so yeah, just Leap Estates is a unique offering in the marketplace. It's the only end-to-end digital solution for a private client practice, where we deal with the wills, the LPAs, the trusts, and then that full estate administration. Built on that Leap platform with 30 years of experience behind it, but our own division based up in Nottingham. It's been a real pleasure to be kind of launching this product. We launched it towards the end of last year. We've had a really great start to this calendar year, and we're looking for really great stuff. Fully integrated with the WillSuite solution. We've got some really interesting AI-based features that will be launching over the spring into the software that's going to really make some massive time-saving changes, ideally suited to private client specialists, either firms or departments within larger law firms, and equally really, really great for estate planning practitioners, will writers, accountants who want to provide that higher level of service when they're dealing with their clients. Finance at leapestates.co.uk. Come to me directly, craig.matthews@leap.co.uk. Always happy to engage and discuss and sort of tell you what we're doing.
Great stuff. Thanks, Craig, and thank you very much for joining me. As always, I've been Alex Simons from the Law Factory LLP, where we are your accounts department, handling all of your back office solutions and consultancy for your accounts and bookkeeping and all that kind of thing. Make sure you go and check us out at thelawfactory.net. We're also on LinkedIn and various other socials, so go and find us there. And this has been LawCast Series 2, Episode 1. Thank you very much for joining me, and thank you again, Craig, and we'll see you again next time.
Thanks, Alex.
You have been listening to the LawCast, brought to you by the Law Factory. Why not subscribe to our Spotify and YouTube channel and head to thelawfactory.net for more information.